out of Texas that has rocked the gun world over the last week. If you are a Pennsylvania gun owner and you own or plan to buy a suppressor, SBR, or a short-barreled shotgun, pay attention. A federal judge in Texas has struck down key National Firearms Act registration requirements for those firearms or those tools. And that sounds like great news, and federally it is. But Pennsylvania law has been built around the idea that these firearms and these tools are legal because you complied with the National Firearms Act. So if ATF eventually stops accepting registrations, Pennsylvania gun owners could end up in a legal gray area where the federal government says registration is no longer required, but Pennsylvania law still assumes that registration exists. That is the problem I'm going to unpack in this video. All right, so the headlines sound simple. No more NFA registration, no more Form 4, no more federal registry, but the actual legal situation is much more complicated here. And in Pennsylvania, there is a state law sitting underneath all of this that was written around the assumption that the National Firearms Act registration system would continue to exist. That assumption may now be coming apart. So let's first talk about what the Texas court actually did. On August 5th, a month and a day ago, federal judge James Hendricks, I call him Jimi Hendrix because we're like that. Jimi Hendrix ruled that in Silencer Shop Foundation versus ATF, that was piled in with another lawsuit, Jensen versus ATF, he ruled that the federal registration and approval requirements for untaxed NFA firearms or other things like suppressors exceeded Congress's congressional authority. Congress eliminated the making and transfer taxes on suppressors, short-barreled rifles, and short-barreled shotguns, but the federal government continued requiring registration, fingerprints, applications, and ATF approval. Judge Hendricks ruled that once Congress eliminated the taxes that supported those regulations under Congress's taxing power, the government could not simply keep the registration system operating on the same constitutional theory. The ruling was based on Congress's enumerated powers. He did not rule based on the Second Amendment. And there's another critical limitation here. The injunction does not automatically protect every gun owner in America. It protects the plaintiffs and, where applicable, their current and future members or customers. Now, the court specifically enjoined enforcement of the registration, the application, and the approval provisions against those covered parties, the plaintiff parties. So do not hear that the NFA was struck down and assume that you can simply ignore federal law today or tomorrow. That's not what happened. So I want to talk specifically about Pennsylvania and how it's going to react now. Pennsylvania, they have their own, we have our own statute here called 18 Code Section 908, Prohibited Offensive Weapons. This section says that a person commits a first-degree misdemeanor if, except as otherwise authorized by law, he makes, repairs, sells, deals in, uses, or possesses an offensive weapon. Now, the code then goes on to define offensive weapon to include, among a couple other things, a machine gun, a sawed-off shotgun with a barrel under 18 inches, and a firearm made or specifically adapted for concealment or silent discharge. Now, maybe that's a lawsuit in and of itself. What the heck? I've shot many suppressed guns. They're never silent. But then comes the provision that matters big time right now in this situation. Pennsylvania law gives a defendant a defense if he proves by a preponderance of the evidence, greater than likely or not, if they prove by a preponderance of the evidence, this would be in court, mind you, that except for certain explosive devices, that he complied with the National Firearms Act. That language has been sitting in Pennsylvania law probably for more than 40 years. Historically, for ordinary gun owners, everybody understood what NFA compliance meant. It meant you filled out the paperwork, ATF approved it, the item was federally registered, and you possess it in compliance with the NFA. And Pennsylvania courts have actually talked about this. This isn't just our interpretation of the statute. In 1984, it's an appropriate year for the times we're in. A federal court in Pennsylvania decided in a case called Ofinger versus Zimmerman. That case involved federally licensed firearms dealers challenging Pennsylvania's ability to enforce Section 908 against weapons that were regulated under federal firearms law. The federal court rejected the argument that federal firearms laws displaced Pennsylvania's authority. And the court specifically noted in that case that the Pennsylvania General Assembly had chosen to make compliance with the National Firearms Act a defense to prosecution under 908. In other words, federal legality did not erase Pennsylvania law. That's the way they chose to set that law up. Pennsylvania had its own prohibition with NFA compliance functioning as the defense, and the legislature supplied that. So, and then more recently than that, we have an even clearer description from the Pennsylvania Commonwealth Court. In 2022, I think it was Crawford versus Commonwealth of Pennsylvania. The Commonwealth Court was considering a challenge brought by Philadelphia, Ceasefire PA, and a couple others involving Pennsylvania's firearms preemption law. The court ultimately dismissed that case with prejudice, but while explaining Pennsylvania's firearms law framework, the court said in that ruling that it's very important here. It said that most items required to be registered under the National Firearms Act, including machine guns, suppressors, short-barreled rifles, and short-barreled shotguns, are prohibited as offensive weapons under Section 908 unless they are registered under the NFA. That statement was the background to the court's preemption analysis, not a holding specifically deciding the legality of unregistered suppressors after federal deregulation, but that tells us very clearly how a Pennsylvania appellate court has understood this relationship between Section 908 and the NFA. And this is why this Texas ruling matters so much here. If you already own a registered item under the NFA, let's separate existing owners from future owners or purchasers here for a second. If you already own a suppressor, an SBR, or an SBS, and you went through that NFA process, you have something extremely important here. You have your existing federal registration. Nothing in Judge Hendricks's judgment orders the ATF to erase existing registrations from the National Firearms Registration Transfer Record. So, and we've been on the phone with Silencer Shop today. They are still processing under the current framework. So, at least for now, this hasn't changed. So if you already have an approved Form 1 or Form 4, you better keep it. Keep your paperwork, keep your registration documentation, because Pennsylvania law has historically treated NFA compliance and registration as the legal protection for possessing these items. So for existing owners of these things, that paperwork is very important under Pennsylvania law. The big question is what happens next. Now, imagine somebody tries to purchase the same suppressor in the future. Suppose that person is protected by this federal injunction. They're a member of one of these organizations. They are a customer of one of these companies. And suppose that the ATF eventually changes its procedures and says, we're no longer accepting or requiring NFA registration for suppressors, SBRs, or SBSs that are covered by this ruling. Well, and then we've got a very different situation, because Pennsylvania still has Section 908. Section 908 still contains its offensive weapons prohibition. And in that section, 908 still says that compliance with the National Firearms Act is your defense. So what exactly does complied with the National Firearms Act mean when federal law no longer requires you to register the item? That is the million-dollar question here. So I would say that there's two serious legal arguments that can be made here. One is, I think it's very favorable to gun owners. If the NFA no longer requires registration, then somebody who purchases the item without registering it has still complied with the NFA. You can't violate a registration requirement that legally no longer applies to you. And the NRA itself has pointed out this exact issue, and they said that if the NFA no longer requires registration of certain firearms, a state law requiring compliance with the NFA should not necessarily be violated by someone who possesses that firearm or that item without registration. That's a serious legal argument. But then there's the other side of this equation here. Pennsylvania courts have historically described these weapons as prohibited under Section 908 unless they are federally registered. The Commonwealth Court, like I just said, they said that exactly in Crawford in 2002. And Oeffinger tells us that Pennsylvania has independent authority to prohibit offensive weapons and that the legislature deliberately chose NFA compliance as the defense. So does NFA compliance dynamically mean whatever federal law requires today? Or would a Pennsylvania court look at the history of Section 908 and conclude that the legislature intended, and they always look for legislative intent, would they conclude that the legislature intended federally registered NFA possession to be the thing that protected these weapons and tools? You can't pretend that question has already been answered. I don't think it has. There is a strong argument for lawful possession without registration if the federal registration requirement disappears. There is also plenty of Pennsylvania statutory history and court precedent here that I would not tell anybody to volunteer to become the test case. And remember, Section 908 isn't some administrative code section here or citation. It is a first-degree misdemeanor. And Section 908 is also specifically listed among Pennsylvania's firearms disqualifying offenses under Section 6105. So getting this wrong can have consequences far beyond one criminal charge. I guess, what about SBRs, suppressors, and SBSs specifically? Short-barreled shotguns are the easiest category to identify here because Pennsylvania's statute expressly names a sawed-off shotgun with a barrel of under 18 inches. Suppressors are reached through the statutory language dealing with firearms specifically adapted for silent discharge, whatever that means. And then short-barreled rifles are less expressly described in the literal words of Section 908, but the Pennsylvania Commonwealth Court specifically identified short-barreled rifles alongside suppressors and short-barreled shotguns when explaining the NFA weapons covered by Pennsylvania's offensive weapons framework. So all three categories deserve attention here. The question is, what can Pennsylvania gun owners do right now? Well, as of August 12, the ATF had not announced that it was stopping the processing of NFA applications. We just got off the phone with Silencer Shop ourselves, and they said that in the 15 states, the ATF is still processing them. So that's important. If you're already considering the lawful purchase of a suppressor, an SBR, or SBS, talk to your dealer and make sure that you understand what ATF is currently accepting and processing. I would not assume, however, that today's procedures will necessarily remain unchanged, especially, God forbid, if we have a congressional change here. The federal government's ordinary appeal period. You know, when Judge Jimi Hendrix issued his ruling, he put a 7-day stay on his own ruling and said that we're not gonna enforce that until 7 days. You have you guys can appeal it within that period, or you have 60 days after the August 5 judgment to appeal. Under the federal appellate rules, I think I think that would put the deadline for the federal government to appeal officially around October 5. And that would be subject to intervening motions or procedural developments. If the ruling stands and ATF ultimately stops accepting registration for those items, Pennsylvania, we could face a very strange situation. Existing gun owners or existing owners of these items have federal registrations. Future owners may have no federal registration process available to them if the ATF chooses to stop this, especially if there's a regime change. And yet, Pennsylvania's criminal statute was written around NFA compliance. And Pennsylvania courts have historically spoken of these weapons as legal through federal registration. That's where the danger here is, or really lies. How do you fix it? This is where we go from the policy to political reality. Yeah, theoretically, the Pennsylvania General Assembly could clean this statute up, but nobody here is going to pretend that that is politically easy right now. Democrats control the Pennsylvania House. I think it's 102 seats to one Democrats, 102 Democrats to 100 Republicans. There's one vacancy right now. And under Speaker Joanna McClinton, she's not going to touch this with a 10-foot pole. She hates everything about self-defense, the human right of self-defense. She hates the Second Amendment. She hates the Pennsylvania Constitution, section Article 1, Section 21, I think. So there's not going to be any reprieve there. Republicans control the Senate, so they might be able to pass a bill, but it would likely die in the House side. Josh Shapiro would veto any fix that got to his desk. And heck, Pennsylvania already has plenty of legislation actively proposing bans on assault weapons and large capacity magazines, like Senate Bill 200. That brings us right back to the November elections, and they matter enormously to what Pennsylvania firearms laws are going to look like next year. Whichever party controls the House, they determine what gun legislation is going to move through that chamber. Whatever party controls the Senate, they're going to determine whatever legislation comes out of that chamber, and ultimately what gets to the governor's desk. That Republican Senate control is the reason why Pennsylvania still looks totally different today from New York and New Jersey when it comes to gun control. And we need to make sure that every single gun voter gets out and votes in these November elections. So here's kind of the simple version of wrap up here. If you already own a federally registered suppressor, SBR, SBS, keep your paperwork. Pennsylvania law has historically relied heavily on NFA compliance as the protection for possession against these weapons. If you are looking at buying one, actually, I should go back on that, and let's keep this in mind here. That's a defense. Any leeway here is going to be weaponized by these anti-gun district attorneys like you can't even believe. So it's all bad. If you're looking at buying one of these in the future, pay very close attention to what the ATF does next. Right now, the ATF has not said that they're going to shut down NFA processing. So you might want to go you might want to go and get one right now. If you've been thinking about it, because I don't know how these elections are going to turn out. The Republican base has the polling on this stuff looks very dismal. The gubernatorial election scene right now does not look good. It looks to, I mean, if you had gunned ahead right now, if you asked me, I think that We're going to go from 102 Democrats to probably 110, 115 Democrats in the House. So I think they're probably going to increase their majority. The Democrats, the communist left, the hate America, unhuman, destroy American heritage left is dumping millions of dollars into 4, maybe 5 Senate races that are going to determine the outcome of control of the Pennsylvania Senate. So they might, if there's no longer a tax and this thing has been struck down by this federal court, I would not be surprised if Democrats take total control in November. I would not be surprised if they totally ban this stuff entirely. So if you've been thinking about getting these things, go out and buy them now while you have the opportunity to do so. If this federal registration system disappears for these things, Pennsylvania law currently, let's just say we keep the Senate, Pennsylvania law currently, if they shut that down, then Pennsylvania law is going to enter territory that this legislature clearly never anticipated. So there is a strong legal argument that if registration is no longer required under the NFA, that an unregistered owner has still complied with the National Firearms Act. But I don't want to be the test case for that, or maybe I do. I'm not sure yet. But there's also 40 years of statutory history in Pennsylvania case law tying those weapons, those items very closely to NFA registration. So until a Pennsylvania appellate court answers that question or the statute changes, neither of which I think is likely right now, nobody should casually assume the answer. The Texas ruling is a tremendous victory for now against the federal NFA registration scheme. But here in Pennsylvania, it's a total shit show, honestly. And it's exposed a weakness here that's been buried inside the state law for decades. So I think you need to understand that distinction before you take any action here. Get ready for a huge fight in these November elections, and you better make dang sure you are making plans to haul everybody you know out to the polls and vote in November. Thanks a lot for watching, guys.